All right, everyone, we're going to get rolling here. In with respect to those of you who are here on time, there might be some more people who will be coming into the room as we go along. Um, a couple of things. Number one, my name is David Feeks. I'm the owner and founder of the Parents Estate Planning Law Firm in Acton. Welcome to our very first Legal Lowdown. This is something new that we're trying. We get a lot of questions from prospective clients, um, and we wanted to set aside some time to answer your questions, answer some of the questions that we hear most frequently from people who have not yet done their estate plan, and sometimes even from people who have done their estate plan and need to recreate and update their estate plan. So we welcome and encourage your questions. There are some questions that came into us ahead of today's meeting, so I'm going to filter some of those questions in as well. A couple of things about today. Number one, we are recording this session. So you are welcome to show your face on screen. You are welcome to not show your face on screen. I am going to keep everybody muted so we have a nice, clean recording for those who couldn't join live today. So if I mute you, please do not take that in any negative way. If you want to ask a question, there's two ways that you can do this, depending on how you feel comfortable. Number one, you can raise your hand, and I will call on you in order. But if you want to, you can just go ahead and raise your hand, and we can take questions that way, or you can type your question into the chat. So just click on chat, make sure your chat box is opened up. You can type your question right into the chat. If you do it that way, if you type your question into the chat, and then we'll just read your question and we'll answer your question. Just put the capital letter Q period in front of your question so that I know it's a question as opposed to any other comments that may show up uh, in the otherwise in the chat. Um, so I just want to make sure there is a way. I know Zoom changes things up, and I'm not immediately seeing a way to raise hands. So other than use the react buttons, but that's to recognize hand gestures. It may be that we just have to do everything with questions in the chat. So let's do it that way. Just put your questions in the chat. Okay. So what I'm going to do is I'm going to start with some questions that have come in to us ahead of today's meeting and get started with some of those. I know sometimes, first of all, it's beneficial for all to hear the questions of others. But what that also may do is it may stir up some questions for you that you had not thought about originally. So I'm going to start with some questions that have come in. One of the questions that we get very often is who needs a will? Or alternatively, do I need a will? And I guess the very short answer to that question is I believe that everybody who's an adult should have a will. Certainly, if you're an adult with assets of any kind, you have a bank account, you have investment accounts, you have retirement accounts. If you own a house or a condo, you should have a will. A will being the tool that you use to identify who gets what of what you own when you die. So that's why everybody needs a will, because you need a will to direct who gets what if you die. If you don't have a will, if you don't have any planning any estate planning documents in place at all and you die, a court is going to determine where your assets go next and who gets what. So, as a threshold matter, a will is your very first step to being sure that um, everybody that you want to get something of yours, that they're going to get that. So, who needs a will? Anybody and everybody with assets should have a will. Adults all should have a will. Another question that we get very often is what is the difference between a will and a trust? And what are the benefits of a trust versus a will? So, as I said, a will is a way for you to identify who gets what of what you own. A trust is also a way to do that, but a trust is a document that is that you create while you're living and that you literally move your assets into while you're living. And really the difference between a will and a trust is a will always has to go through a probate court process, whereas a trust does not. So if you just have a will and you own assets in your own name, those assets are going to go through a probate court process. Your will get filed with a probate court, but your family will essentially have to deal with a court process. That court process in Massachusetts could take a long time. It takes at least a year to probate an estate. Very often it's longer, but it's at least a year. Um, it can be cumbersome, meaning your family doesn't have immediate access to your assets while they're going through probate. Uh, it means your family won't, there's an expense to probate, which can run into the tens and sometimes hundreds of thousands of dollars. And probate is a very public process. So to have a will and to leave assets through your will means to make all of your wishes and desires and instructions public, because anybody can wander into a probate court and read your will after it's been filed and can see what you owned and what it was worth and essentially who's getting what. A trust, by contrast, is essentially a will substitute within an estate plan. And the idea of a trust is you create it while you're still living, and then you move your assets into the trust. Your real estate, you move that into your trust. Your bank and investment accounts, you retitle in the name of your trust. And the difference is the assets that are in your trust when you die do not have to go through a probate court process. So your family doesn't have to deal with a probate court for a year or longer. Your successor trustee, the person you choose to take over the management of your assets, would get near immediate access to your assets. The whole thing stays private. A trust doesn't get filed anywhere publicly. So what you own and who's getting it all stays private. It doesn't become a matter of public record. There's no probate, so there's no expense of probate. And by the way, if you've got young kids, this is the easiest way to manage assets for the benefit of your kids. So you're going to need someone to take over and manage assets for them until they are old enough to receive those assets more directly. And so a trust is just the easiest, most private way to pick someone to manage everything for your young kids until they're old enough to receive those assets directly. So again, we very often get asked, what's the difference between a will and a trust? So there you go. And what are the benefits of the trust? And so I've shared some of the benefits. Those aren't all of the benefits of the trust, but some of the more significant benefits of the trust. The primary one is getting your family, your loved ones out of that probate court process, so they're not having to deal with a court and they're not fighting in court. And kind of a follow-up question to that around a trust is we get asked very often, what amount of assets do I need to have in order for it to make sense for me to have a trust? And the answer is um, it doesn't matter how much your assets are, doesn't matter how much you own. All that matters is how do you want things to go if something happens to you. So there's no bright line that says if you have this amount of assets, you should have a trust. It's merely a matter of do you want to keep your family out of that probate court process? Is that important to you? And if it is, then a trust makes sense. I've had clients with very few assets create trusts because the trust was important to them in some way, sometimes only as a mechanism to keep the wrong people away from their money, whatever that was, to keep the wrong people from ending up managing the money for their young kids. For example, to keep a divorced spouse out. So sometimes that might be the only reason to do it, but it's still a valuable reason. And it's all around does a trust make sense for you? So again, no threshold for assets. It's really just about do you see value in the trust itself? Okay, so I noticed there are some questions coming in, so I want to pivot over to the questions that are coming in and start to answer those. So one question, I currently live with my 82-year-old mother who transferred her house into my name only. I'd like to leave my kids the property. However, they're both on the autism spectrum, and I'm concerned that they can be easily persuaded into signing paperwork that is not in their best interest. Should I put the house into a trust to keep the house from ever being taken away? Okay, so just as a threshold, this kind of legal lowdown is designed to be educational. So we want to keep that framework around this, that this is educational, but not necessarily designed to answer any specific situation. But don't worry, Edna, I'm going to give you a general answer for that. So I promise that. And also that I cannot provide any of you any form of legal advice we're on Zoom together. I don't know you. You don't know me yet, other than what I've told you so far. We're not creating an attorney-client relationship in any way here. And I'm going to answer questions around the law in Massachusetts. That's where the attorneys in our firm are currently admitted. It's where I'm admitted. So anything I answer would be relevant to Massachusetts and Massachusetts law, but not relevant to the laws of any other states. Okay. So the answer to that question generally, because again, I'm not offering advice as to a specific situation, is if a house is owned in the name of a trust, then through the trust, you can create some protections around that piece of property if you were to die. So if you own a piece of real estate, you own a house, and you put it into your trust, and you want to put some restrictions on what happens to that house if you die for whatever reason, because your kids are financially immature or because they're not financially or emotionally ready to take on the responsibilities, then a trust would be a way to manage that because it would allow you to appoint someone else to manage the trust until your beneficiaries, if it was your kids, were old enough and mature enough to make wise decisions about what to do with that resource on their own. And again, in this case, we're talking about a house, but we could just as easily be talking about a bank account. We could just as easily be talking about an investment account if you thought your kids were not quite ready to manage those assets in a financially or maybe an emotionally mature manner yet. You could have someone else take over and manage those assets for their benefit until they were old enough to manage that themselves. And so that could be true of a house. And as I said, it could also be true of bank accounts. It could be true of investment accounts. And so in that scenario, then a trust becomes a really good tool for making sure that beneficiaries don't receive assets before they're ready, and that they only receive assets when they're ready. So great question. And again, I just needed to answer that very generally, but I hope you kind of are able to take what I just gave you and now apply it to your own particular situation. The next question that we've got here is, if you have a beneficiary on your checking account, does that give them permission to your items? And Sheila, I'm going to read in here. Will or trust if don't have their name on the will or trust. Let's just I'm gonna again, Sheila, I'm gonna read into your question and make some assumptions. So if I don't get this right, feel free to keep typing. If you have a beneficiary on your checking account, what that means is that if you die, that account is going to go to your named beneficiary. That is the very nature of a beneficiary designation, whether it's on a checking account or an investment account or a life insurance policy or a retirement account. If you die, that asset is going to be transferred to your named beneficiary. So if you have a beneficiary on your checking account, when you die, your beneficiary is going to receive that checking account or the assets that are the amount that's in that checking account. It does not mean that that person has control or access to your checking account while you're still living. In order to have control over your checking account while you're still living, that person would have to be a joint owner on the account as opposed to a beneficiary. A beneficiary only takes after you die. Now, Sheila, here's where I'm going to read into your question a little bit more. And again, if I don't get this right, forgive me, just kind of give me a follow-up question. I'm reading into your question is, does a beneficiary designation override what you put in a will or a trust? And the answer is yes. Any beneficiary you name for a bank account, an investment account, a life insurance policy, or a retirement account does override what's in your will or what's in your trust. So just be aware of that. Your bank is only going to look to your beneficiary designation to figure out what to do with your checking account when you die. They're not going to look at your will. They're not going to look at your trust because under their rules, the beneficiary gets it when you die. So in that sense, it does override your will and your trust. And again, you didn't express your question exactly that way, but I was taking some liberties to read in. Let's follow up. So Sheila's follow-up question is, so bank joint owner is better to have than a beneficiary? I don't know. If you want the person to have access to your account while you're still living, then a joint owner is a way to accomplish that. If you only want the person to get your checking account after you die, then a beneficiary is a way to do that. So it depends on what you're trying to accomplish. So again, those are the two scenarios. And again, like Edna, I'll let you apply my answer to your specific situation. Joint owner would have access to the account while you're still living. Beneficiary would only get the account after you die. So depending on which is most important to you, then you can figure out what's the right answer. So I want to go back to some of the other questions that people have shared with us in advance of today. And again, if anybody else has questions, feel free to drop them into the chat. Start with a capital letter Q, and then post your question. One question we get very often is, can a trust be modified or revoked after it is created? And the answer is it depends. There are two different kinds of trusts. There are revocable trusts, capital R-E-V, revocable trusts, and there are irrevocable trusts, capital I-R-R-E-V. Revocable means you can change them, you can modify them, you can revoke them. An irrevocable trust cannot be changed or modified or revoked after it is established. So can a trust be modified after it's established? It depends on whether it is a revocable trust, in which case the person who creates the trust can modify it or revoke it or amend it, or an irrevocable trust. And in that case, the person who creates it can't change it or modify it or amend it. Um, so that's a question we get very often. Um, Another question we get very often is, if I create an estate plan in Massachusetts and I move out of state, I move from Massachusetts to Connecticut, will my estate plan still work? And the answer is substantially yes. A trust created in Massachusetts is still a trust in Connecticut. A will legally created, validly created in Massachusetts with all the formalities that are required for a will are the same formalities as Connecticut. Two witnesses, a notary. So a will created in Massachusetts will work in Connecticut, will work in California, will work in Florida. A trust created in Massachusetts will still work in other states. Healthcare proxies created in Massachusetts, the documents that you create to allow someone to make medical decisions for you if you can't make those decisions for yourself, will still work in other states. So if you create a healthcare proxy in Massachusetts and you move and you are in Florida traveling and you're injured and you're in the hospital, your healthcare proxy will be recognized in Florida, and the people named in that document will be able to make medical decisions for you if you can't make those decisions for yourself. Same thing for a power of attorney, which covers legal and financial decision making. So a plan you create in Massachusetts is a plan that will work in other states. So yes, if you move out of state, your state plan will still be legal. Here's the caveat to that, and that is if you move permanently from Massachusetts to another state, I think, my opinion, I think you should have your estate plan reviewed by an attorney in the new state that you've moved to. So if you move from Massachusetts to Florida, by all means, have an attorney in Florida review your estate plan to make sure it fits with all the legal uh, the differences in the law in Florida. Your Massachusetts plan is still legal. It still will work, but it may not work in all the ways you intended it to when you still lived in Massachusetts because there's differences in the law in Florida. So again, my opinion is you should have an estate plan reviewed by an attorney in the state to which you move permanently. So I think that's an important piece there. But your plan would still be legal even if you moved out of state and did not change it. Um, and then the other question, and again, if there's more questions from any of you that are here today, feel free to pop those questions in, and then I'm going to give you some more resources. But the other question that we get asked from time to time, and this is actually a question that shows up when you take wills and trusts when you go to law school, and that is a handwritten will legally valid? And the answer is yes, a handwritten will can be legally valid. Not always legally valid, but it can be legally valid if it meets all of the formal requirements of a will in Massachusetts, which is that it's in writing, that it is signed by the person creating the will, and that when the person creating the will signs the will, that their signature, their act of signing the will, is witnessed by two disinterested witnesses. And by disinterested, I mean people who are not otherwise named in the will itself. So you can handwrite a will. It is valid if you sign it in the presence of two disinterested witnesses who also sign your will, attesting that they were present when you signed, they watched you sign your will, that you appeared to them to be 18 years of age or older, and that you appeared to be under no constraint or undue influence in signing your will. And in those circumstances, a handwritten will is just as valid as a typewritten will. Here is what's not valid. You're about to travel with your spouse and you have little kids. What is not valid is you write down on a scrap of paper as you're heading out the door to the airport what you want, who you want to take care of your kids if you die in a plane crash, and who you want to get your assets if you die in a plane crash. That is not a valid will. A handwritten note in and of itself is not a valid will. It could be a valid will if done correctly, as I said before, but you cannot rely on just writing things down along with the instructions for the babysitter or the pet sitter. That's not valid. It's not enough to have a conversation with people. That's not valid. That doesn't create a valid will. So you need to have the right estate plan in place so that you can name guardians for your kids if they're young, that you can identify who you want to get your assets if something happens to you, so that you can identify who you want to step in and make decisions for you if you're incapacitated. So I just want to make that very, very clear, because sometimes people are under the impression that they can just write notes and that somehow that is legally valid. No, the notes in and of themselves are not legally valid. I'm going to add one more question in here just because it's reminding me of something. And that is, I get asked all the time, there is an assumption by parents of young kids who have named godparents for their kids that somehow godparents are legal guardians of their kids. Not true. Your godparents are not the legal guardians of your kids. The only people who are the legal guardians of your kids are the people you formally nominate to be the legal guardians of your kids. And that all has to be put into the correct legal documents. So godparents are not guardians. The godparents of your kids are the people who have undertaken a moral responsibility to continue to raise your children in your and their chosen faith, but that does not make them legal guardians of your kids. So guardians, not godparents, godparents, not guardians. The other question that's come in, and again, this is a very common question, what is the cost of a trust and a will? So Stacy, I cannot answer that for you with any specificity, okay? Because like a lot of things, it depends. Estate plans are different for everybody. There are no two estate plans that are exactly the same. And so without having met you and without knowing what's most important to you, without knowing what you are trying to accomplish, I can't tell you what an estate plan, which might include a will, which might include a trust, would cost. I will tell you this. The prospective clients who meet with the attorneys in our office in our initial kind of planning session, in the first part of our planning session, will always know what a will or a trust would cost if they chose to hire us under a planning level. So in our office, we have different planning levels, and we present those to a prospective client after we've walked them through where are you now in terms of planning, what would happen to your kids if they're minors, what would happen to your assets if you died, what would happen if you became incapacitated, where we've walked them through where would you rather be instead if where you are is not where you want to stay. And then we introduce our planning levels and we help a prospective client to decide, is there a planning level that makes sense for you? And are you ready to hire us to start designing a new plan for you under that planning level. And those prospective clients know, because we are fully disclosing to them, this is how much that planning level will cost. We always go by flat fee. So there is no answer, unfortunately, to how much does a trust or a will cost. That is dependent on a lot of factors, including what's most important to a prospective client, what they're trying to accomplish. Do they have young kids or not young kids? What are they including in the plan? So we do all comprehensive planning. We don't just do trusts. We don't just do wills. So I could not, in fairness, answer that question. But if you ever were to meet with any of the attorneys in our office, I promise you, at the end of the first half of our meeting together, you would know exactly how much it would cost to implement a specific planning level. That much I can promise you. Um, Another question is, how does the court decide who becomes a guardian if one isn't named and both parents die? By the way, this is a great question, and it illustrates why it's so important for you to have a plan in place if you have young kids. Because if you don't have a plan and both parents die, a probate court judge is going to make the decision as to who takes care of your kids, who is going to be the legal guardian of your kids, who is going to raise them until they are 18. And while that judge is doing the very best they can, and is doing what they can to look out for the very best interests of your children, that judge, by definition, most likely doesn't know you, doesn't know your kids, doesn't know your family, doesn't know what's most important to you, doesn't know what's least important to you, doesn't know who you would choose over everyone else to raise your kids, and maybe as importantly, doesn't know if there's someone in your family you know you wouldn't want to be the guardian of your kids. So the only way for a judge to know exactly what to do and who to appoint is for you to leave a roadmap for the judge to follow. And the roadmap that you create are the legal guardians that the formal legal guardians that you nominate via the guardianship documents that you create for your kids. That includes a will. It includes separate guardianship nominations for both long-term and short-term guardians. But again, if there's no plan and both parents die, a judge, a stranger to your family, makes the decision, and they may not make the decision that you want. So the only way to be sure that they will make the right decision is for you to create a legal plan that says, here's who I legally nominate as the guardians of my kids. And that allows the judge to follow that roadmap that you have created for them. So that's a great question. And it gives me an opportunity to point out one of the dangers of not having an estate plan if you have young kids, and that is a stranger is going to make the decision over who raises your kids, and it might not be the person that you want. Okay, so those are all the questions that have come in. Those are all the questions that came in ahead of time. So what I want to do is, before we wrap up, I just want to give you some resources for you to kind of continue your education if you're getting yourself educated about estate planning. So if you're the parent of young kids, we're going to drop a link into the chat for our Kids Protection Planning Guide. And that is a guide that you can download, you can print out, you can make reference to, that will give you lots of information about how to create a good guardianship plan for your minor children and how to create a really good overall plan to take care of your minor children, even around assets. So we're going to drop a link into the chat for the Kids Protection Planning Guide. If any of you are empty nesters, if your kids are already grown and out on their own, we're going to drop into the chat a link to our empty nester guide so that you can download and print out our empty nester guide. And that'll give you some more kind of information about how to create a really good plan for your adult children in terms of assets and even around incapacity for you. Because when you're an empty nester, your focus, what's most important to you, is different than it is when your kids are still young, both in terms of do we need guardians, which you don't once you're an empty nester, and how do we want to manage assets for the benefit of our kids? So those two resources are now up in the chat. I'm going to have Lisa also drop into the chat a direct link to the resources page on our website. Our website is parentsesstateplanning.com. But to make things easy, we're gonna drop the resources page, a link to that page right there. And you can go to that resources page, and we've got lots of resources on our website, FAQ videos, other guides that you can download. So that is a good way for you to continue your estate planning education by hitting our resources page and just grabbing what makes sense. And Lisa's also dropped in a link to our events page. We do webinars on a regular basis. So you can sign up for a webinar where we'll take a deeper dive into estate planning in a more structured way than we are here today. Here we're just doing some Q&A, kind of free form. But if you sign up for one of our webinars, we will go through everything you need to think about, whether you're a young family, whether you're an empty nester. As I said, in a more structured and in a more of a deep dive into estate planning. And we do some live events. So when we have live events upcoming, you'll see them on our events page. If you like webinars, a webinar is a great way to get information. If you like the touch of in-person events, we've got in-person events that we do on a monthly basis. So check out our events page, and you'll see some of those upcoming events. But otherwise, I want to thank you all, those of you who joined us live today, and for posting your great questions. Thank you very much for that. We are recording today, so we're going to send a recording out to everybody who registered, even if you couldn't make it here live. And we look forward to having a further conversation with you about estate planning for your family. Our office is located in Acton. We serve clients both with in-person meetings and with Zoom meetings. So a lot of clients who do not live in Acton or in the surrounding communities will still work with our firm. But we'll just start off that relationship with a Zoom meeting, and we'll do design of their estate plan through a Zoom meeting. And that's fine too, whether in person or by Zoom. But I want to thank you all for joining us today. I love hearing questions about estate planning. I enjoy answering those questions. I like educating all about estate planning. So thank you for joining me. Thank you for bringing your good and thoughtful questions. And I hope to have an opportunity to talk with you again at some point in the future. Thanks, everybody, for joining us today. Have a great day.